Today we're going to talk about wills and the basic of drafting a will and what needs to be considered when preparing a will. This is not an exhaustive or certainly advanced class, but the idea of doing this is that it should be able to allow you to prepare a basic will, and I would certainly always recommend using good precedents when doing so. So, first of all, what is a will? A will is a document which is a deed which is executed by a party stating their last wishes after they pass away. The will grant powers for someone to deal with the assets or deal with a person's estate on their death. That's an important point because the will has no authority while somebody is alive. It only applies on someone's death. That is what a will does. While somebody is alive, if they want to grant somebody the authority to deal with their assets, they have to appoint them as a power of attorney, which is a separate issue. So there are two main parties to a will, or sorry, three really. You've got the executors, who will do whatever the will states, beneficiaries who benefit from the will, and the testator is the person who makes the will and executes it accordingly. The requirements under a will are found under the Wills Act, and then it must be dated, written and signed and witnessed by two parties. It's very important, it's different to other deeds which are witnessed by only one. A will needs to be signed, witnessed by two parties when witnessing the will. So, when you're instructed to draft a will, you go back to basics, know your client, find out who your client is, identify your client and see who is going to be the person making the will. You then have to think about capacity. It's a very, very important part of a will. Does the party wishes to make the will, do they have the capacity to do so? Capacity means that they have the understanding, and it can be quite tricky. For example, a person with dementia may have the capacity to make a will, and a good rule to follow is that if the person making the will is aware of their assets and aware of who they're gifting, then usually they have the capacity. So for example, with dementia, especially early on dementia, people lose and gain capacity. So the test is that capacity must be as at the time the will is executed. So they could have capacity, for example, when they're giving the instructions, but they lose capacity. You have to make sure that when the will is executed, they have the capacity at that time. It can be a little bit of a minefield, and what I always recommend to people is follow the golden rule. The golden rule is that if the client is elderly, obtain a medical examination certificate or a medical certificate, preferably from a suitable professional, to confirm that the person has the capacity as at the date the will is signed, and they can possibly, or they should also act as a witness as at that date, and then any notes will need to be kept. If it's obviously a younger person, then you don't have to worry about capacity, but that's certainly something you need to think about. We also need to ensure that the person is not being unduly influenced in any way, and then it's important therefore that you see people making a will by themselves, free from any third parties. But many clients come and see me saying with their children or husbands or wives, and you have to turn around and literally ask them to leave and ensure you see the client by themselves. So you check the capacity and you see the client by themselves, and I would also ensure that you make a note that the client was seen by themselves. Despite doing all of this, you will not be able to stop someone challenging a will. Challenging a will is a right. People often ask me, well, how do we stop challenges? You can't stop challenges. People can always attempt to make a challenge to the will, but what we can put in place are points to ensure that if there's a challenge made, the testator's wishes are met. So quite often it's either on capacity, or I found that the person was unduly influenced, so you can easily rule those out. The other way a will can be challenged is if, say, it's a dependent saying, well, I was a dependent to the person and they've left me out. If quite often that happens where a party may want to effectively cut out a child, I usually ask them to give a good reason to do so, a full letter explaining why they're doing it, or put a clause in the will as to why they don't want that child to benefit from their estate. As I say, even despite doing all this, it's always advisable to say to your client, we can do all these preparations, we can say that you've got capacity, we can show you've not been unduly influenced, we can say as to why you decided not to give that to the child, however they still may challenge it. But what we're doing here is protecting the firm. So going into a will doesn't have to be very complicated, it's very, very, very simple. And a classic example of if I wanted to draft a will is I, Aliosman Halil, hereby appoint my wife as my executor and leave everything to her. That's signed and dated and witnessed by two people. It is a perfectly valid will. I have identified myself, I have identified my executor and my beneficiary. My executor being my wife, my beneficiary also. That comes on to an interesting point. When identifying parties, you have to be able to identify who you appoint. We often state a person's full name and their address. I only have one wife, I promise you, and I promise her. And clearly it's obvious who that is, therefore you don't have to spell her name out. Same as, for example, if you have only one son, or your son Peter, or your son Michael. You don't have to put the person's full name out because it's clearly identifying who that is. If you're using a group and you're saying my children, that may be more of an issue, but I'll come to that in a moment. So, going back to drafting a will, it's usually started by stating the name of the testator. So in my case, it is I, Aliosman Halil, hereby make this my last will and testament. Good way to start, identified myself and stating it's my last will. I can then turn around and state if I would like any burial wishes. So my next paragraph could be, I would like to be cremated, I would like to be buried in North Cyprus, I would like to be buried with a plot next to my wife, or you can say that I have already paid my funeral plans, and you can put that in the will. You would then quite often identify the executors. So I could, for example, say that I appoint my wife as my executor. If I usually recommend to people to appoint at least two executors, or to appoint a substitute. The reason being here is you would keep the control in yourself. If an executor is unable to act, then the beneficiaries would then have the rights to be able to do so. So I would often say, I appoint my wife. If my wife is unable to act or predeceases me, I appoint my brother-in-law, Mehmet. These are the parties as the executors. They do what the will says. They may or may not be beneficiaries. They could be beneficiaries. So in my example at the start, my wife was the executor and the beneficiary. In this particular case, we're appointing them executors. They are the parties who actually do whatever the will is requiring them to do. So they have the authority to make sure that burial arrangements take place, that if any gifts are given, etc. Their authority actually comes from the will, not the grant of probate. I'll come on to what the grant of probate is, but it actually comes from the will itself. Okay? So we've then identified the parties. Some people may want to appoint a law firm. I've had that. Now, if you're going to appoint a law firm, again, please use a good precedent. We've had people where they've drafted it and they've stated that they appoint a specific partner. That is a mistake. The partner then is being appointed as the executor. We've drafted as to say, I appoint the partners of Hutchins & Co. solicitors, and I wish only two partners, a maximum of two partners, to be appointed as my executor. You would then state a clause to make it clear that any subsequent firm can be, or any subsequent firm that takes over Hutchins & Co. Would be appointed as the partners. Again, use a good precedent. We can then go on to say if there's going to be any specific gifts. So we could say that, for example, if I had a particular watch, if I had a car, if I had a certain amount of money I'd like to be gifted, these are specific gifts. Usually these are gifted free of tax. You can ask a client whether they want the tax, any inheritance tax to be paid by those parties, but quite often they're gifted free of tax. So in our example, it would say that I give free of tax £10,000 to my brother-in-law Mehmet, £10,000 to my brother-in-law Ahmed, etc., etc. These are specific gifts. You may have a particular family heirloom you'd like to give to a child. For example, many of my female clients may want to have their jewellery go to their daughter or their etc. So then you would say any specific gifts. Once the specific gifts have been set out, you would then usually grant or state the residuary gift. So in our example, you would turn around and say, for example, I would then ask for my remaining estate to be collated, and I would pay any tax due, as in with debts or liabilities, and the remainder of my estate is to be divided as follows. That is a residue. So, first of all, you've identified who you are, you've given the person as the executor, you've then stated any specific gifts, and the idea being is that anything that's left, you would say to be bundled up. They pay any inheritance tax from the residue, they pay your liabilities from the residue, and then you would then turn around and say it's to divide it. It could be divided by a specific group. For example, you may turn around and say, I would like it to be gifted to my children, or you could say specific people. The advantage of saying my children is that I may have future children, future children which are obviously not alive at the time of the will is made. The advantage there is I don't have to make another will to include them in there. If I state my children specifically, then that would be any future children would not be included. So it's advisable, in my opinion, to you have to sometimes answer very uncomfortable questions, and usually, unfortunately, it's to the men to say, oh, do you have any children you're not aware of? I've had some interesting answers. So you may want to have to think about that. And then what we usually say is that I gift it to my children who are alive as at the date of my death. And then you would usually put a sweeping clause to say that any children who are not alive at the date of my death, their children shall inherit their share. That's usually the way it's dealt with, or you have a specified beneficiary, for example, your brother, your sister, and anybody who's not alive would have to inherit as their share. Now, it must be clear that you get clear instructions. Some people actually do not want their children to inherit. We actually had a case where the solicitor drafted it incorrectly. They actually wanted their siblings to inherit, and if one of the siblings passed away, they wanted the remaining sibling to inherit their share. They were very specific about that. Unfortunately, the solicitor who drafted it did not draft it correctly and drafted it so that the siblings, when the sibling passed away, their children inherited it. And we had a real situation here which unfortunately resulted in a claim. Okay? So you have to be clear to make sure you ask the question, what happens to it? And if there's going to be any charity, sometimes we want to leave something to a charity. Clearly make sure you identify the charity, use the charity number, and clearly identify it. And I will also advise that you include a clause where it's a charity that if that charity no longer exists, it will go to a charity of the executor's choosing with a similar constitution to that one. So that's generally what it is. So there's your will, and then the rest of your clauses will be general clauses giving powers to your trustees. I usually follow the steps clauses. These are the Society of Trust and Estate Practitioners clauses, or saying any good guide or good precedent will have those set out. These are important because it say, for example, who gets receipts, if you've got a child under 18, etc., etc. Quite common clauses would be a lifetime trust, so that it goes to, you may want to turn around and say to someone, you get the estate while you're alive, but actually it's actually gifted to the children. Example of this would be a husband and wife. The husband who passes away, may pass away first, says the estate of the property can go to the wife first of all. She has a right to live there, to enjoy it, but actually it belongs to the children. That way it ensures some sort of continuance of the property. Another one maybe is that people do what's called mirror wills. For example, a mirror will is usually again between husband and wife. So in my particular case, I stated that my will is that I leave my wife as my executor and I leave everything to her, and then if she agreed to cease to speak, it goes to my children. Her mirror of that would be she appoints me as the executor, leaves everything to me, and then if something happens to myself, goes to our children. So as I said, a mirror will is that's what often a mirror will is. One small point to always remember is that with a will is that with property, quite often people would like to leave their share of the property to somebody. An example would be a business person who owns property with other people. They may want to leave their share of that property to a specific child. They might want to leave their share of that property to their wife, but they own it with another business partner. What you have to check is that the property is held as tenants in common or joint tenants. And you have to ensure, if necessary, that you serve notice to separate the title. I've seen this time and time again where practitioners haven't taken this step and it's caused an issue, or actually will writers often don't think about this. They don't take this extra step. So where someone has a property and they want to share, say, I leave my share to, the question you should be asking is, I need a copy of that title, I need to check the title, I need to see if it's tenants in common and joint tenants, and then you need to advise them accordingly to say that if the rights of survivorship applies. Okay? Always remember, you cannot separate legal title. And finally, when drafting a will, you may want to think about or be aware of certain inheritance tax considerations. The current law, when we're making this video as it stands, is that there's a spouse exemption and that you can use the nil rate band on if you haven't used it for one. So previously, I remember when I first started drafting wills, you would always include in there a gift to the child of the nil rate band. The nil rate band is the amount that each person is allowed to gift free of tax. Currently, it is 325,000 with the top up of up to $500,000 with the for personal property, your personal property that you live in. by gifting, quite often what people do is they gift everything to the spouse. You have the spouse exemptions and no tax is payable, and then the children can use both parents' nil rate band, and if it is the matrimonial home, then that goes up to, the nil rate band goes up to £1 million. So you want to think about these IHD considerations, because if they take that away, then it may affect the way you draft a will. And that is the basics of will drafting. I've got a number of people here. Any questions?
You know, when a property is owned by a company, and one of the partners in that company passes away, obviously the property isn't held as tenants in common because it's held in the company name. How would they benefit from? You would have to check. First of all, you'd have to check to see if the any agreement, shareholders agreement, make any allowance for that. Alternatively, if it's held as a company, then the shares of that company that the party owns would pass on to the estate. Okay, that's what it is. Any other questions at all?
Yeah, I've got questions just about, so you mentioned the lifetime interest, and I heard that can help with avoiding care home fees.
No, that doesn't work. I mean, people talk about doing that, trying to avoid care home fees.
Okay, all right.
You've got to be. No, I've seen this before as well. You've got to be very, very careful with it, where people try and do that, and I think the care home will let's say you try to do that to avoid the care home fees.
Okay.
I mean, you may want to separate the title and transfer everything else, but it's all going to be done in very, very good time, like very early on.
So basically, let's say a case study, a case study X, the person cannot afford care home fees. How is that based compared to someone who can?
That's a complicated question. That's going to be out of agreement of this.
Right.
I'll come back to that with you separately.
Okay.
But so I just wanted to go back and just say that a will actually gets negated on certain lifetime happenings. For example, when you get married, the will becomes negated. So if you make a will before you get married and then you get married, your will becomes invalid. You should actually make sure that you're making this will in contemplation of marriage. Put that clause in there. And we always recommend to people, you should really update your will every 5 years or so, is look at it. And that's a good thing for people to look at, is look at their will and update it accordingly. And also another big trap are divorcing couples. Obviously, parties are divorced. They may want to make a will very, very quickly, especially if they have properties, because quite often they don't want the share of the property to go to the cheating husband or the cheating wife, if that may be the case it may be. I've actually had this a few times, where I turn around and say to them, you're divorcing, why are you divorcing? Or they've failed, whatever it is. Right, have you made a will? Because if you don't make a will, then all of a sudden what will happen is your share will go to your husband or your wife, and then quite often then they usually freak out very, very quickly and instruct me to make a will immediately. So there's that sort of point just to be aware of as well. And finally, just to talk about probate. Probate literally means proving the will. People think what probate is that you've taken the will to court and you've proven it is the last will. If you have a will and then you make another one, the new will takes precedent over the old one. Okay? What probate does is showing, you're saying, this is the last will, I've proven it's the last will, probate is Latin for proof, and that's all it is. It's just literally showing that you've proven this is the last will, but the actual authority for it comes from the will itself. That's the end of that one.